fifth felony in Chambers County while you're on probation for 3 here. All right, are you Jameldrin Willridge? So we're here. Mr. Willridge has 3. He's on probation in 3 cases: 18-28743, 28744, and 30139. And then there's a new offense of burglary of a habitation in cause number 25 DCCR 1804. And there was an agreement that was reached, and he entered a plea of guilty to that burglary of a habitation case. The agreement was for a 10-year deferred probation, restitution to be determined, and that those motions would be dismissed. There was an issue between, obviously, when he pled and now, which required me, I revoked that bond because he was arrested on May 26th in Chambers County for a 3rd-degree felony and a Class B misdemeanor. So obviously that
kind of nullified from all of our position where we were with that agreement, Judge.
Right.
So you know.
Okay. So where are we? I mean, I'm going to at this time reject the agreement formally so we can start all over. You guys negotiate whatever y'all want to do. If we need to get more information about that Chambers County case, but obviously I'm not inclined at this point. I see no reason, if those allegations are true, that Mr. Willridge would get another opportunity on 3 felony probations with now the new burglary of habitation here. And while literally days after he entered pleas here, went and was at a minimum in a county that he wasn't supposed to be in without permission and arrested for those offenses. So my thought is, do you have any information on those yet?
No, Judge, because when we broke last month, it was primarily, obviously not knowing that was going to happen in Chambers County, for the restitution in the burglary. Because we all had the discussion about how could tennis shoes cost that much.
Right.
And I have spoken several times with Mr. Riley, who the court knows is an excellent PSI writer. And he assures me, and through an affidavit from the complainant in that case, that that's what the restitution amount is. So I feel like we could ask for that and see if he'll pay it, and so be it. Then obviously the new offense came up, which then put us all kind of back at square one. The court is aware that I have always been a little bit more outgoing with Mr. Wildridge, wanting to give him an opportunity. I'm not suggesting I still don't want to do that, but I certainly understand the position that we're all in. I mean, the files are just stacking up.
Yeah.
And
I mean,
and Judge, only thing I can say in that regard is that, you know, of course, I've dealt with him for a long time in this situation, and, you know, he understands it was inexcusable for what happened in Chambers County. But I will say that it's the first time that since then that he's actually opened up to me as far as asking for the type of help he needs for any underlying issues that may be there. And it's something that his family was actually in the position to try to get started when the whole bond situation occurred, but of course he turned himself in, did what he's, complied with your orders.
And that, per our conversations, I think, Judge, it's important to note that that has to do with underlying mental health issues that go directly in correlation to his behavior. Although it doesn't excuse his behavior.
No, it doesn't. And I guess, you guys know, he's been on probation since 2018.
Right.
There's been every opportunity to take advantage of any help. It's not like he just did all this and we say, okay, well, now let's do this. We've got help for him. It's been years that we've gone through motion to revokes that have been dismissed. And
the only thing I can say is a lot of times in these type of situations, of course, the help doesn't work unless the person is ready for it. And of course, like I said, this is the first time he's opened up to me as far as trying to get that. And a good thing for him, he does have the support system there that he can try to get that help.
And that's so great. And it's also such a shame at the same time, because I'm guessing he's had the same support the whole time. It's not like people are just now stepping up and saying, let's help him out. Right? They've been there the whole time. And here we are with our fifth felony in Chambers County while you're on probation for 3 here. Here's what I need. I'm not going to do anything today. I want to find out, see what you guys can find out about Chambers County, what the status of those offenses are. Get Mr. Lewis whatever you can, so that I can also have a little, even if it's just a PC, so I can see a little more about what the underlying offense allegations are, and then we can kind of reconvene and I do see, I guess, where if you guys want to try to tell me what some agreement is, I'll see if I'm willing to go along with it or not. Obviously, probation, I value your opinion, and so
More likely than not, Judge, if it's okay with the court, probably will not come to you with any type of agreement, maybe just more of a conversation. Obviously, we're all aware of the situation that all of us are in right now with respect to individuals this age that have been given multiple opportunities and what else going on. So
we're also going to go through, we can do it. I don't know, there probably needs to be amended motions on those 3
to add those.
to add those allegations, and I'm not going to just sign a dismissal on those motions. I want to go through each and every allegation of the motion, get pleas of true or not true, and then we'll go forward. So between now and then, if you can get, I guess, any type of hearing done so that we can get those new allegations in the hearing, in the motions to revoke, we'll go through those at the next court date, and then we'll see where we are from there.
You get that.
Okay. All right. Thank you. Go back to the bailiff. Good morning. Are you Quentin Sells?
Yes.
And we've got cause numbers 25 DCCR 1473, 1474, and 1475. Mr. Sells is charged in each of those cases with assault on peace officer. I'm going to take judicial notice of the court's file in all 3 of those cases. Mr. Sells was previously found not competent to stand trial and was sent to the John Dunn Behavioral Science Center for competency restoration. I have received the report from them. In that, it includes a trial competency evaluation report dated May 4th of 2026. The opinion in that evaluation from a Dr. Emery is that Mr. Sells is currently not competent to stand trial, and that further treatment would be necessary for competency restoration. In addition to that, I also have the forensic psychiatry report, which is dated May 5th of 2026. Also, it is from a Dr. Shahani, also has that same opinion that Mr. Sells is still not competent to stand trial. Then I also have a physician certificate of medical examination for mental illness. This is from Dr. Shahani, dated May 5th of 2026. It makes the finding as well that Mr. Sells is not competent. It does state that he does not meet the criteria for inpatient, but would meet the criteria for an outpatient commitment for competency restoration, that the nature of his mental illness is severe and persistent, and that without treatment, he would continue to decompose and or deteriorate and not achieve competency. I also have a physician certificate of medical examination from a Dr. Polizzato. This is dated, well, let's see, May 13th of 2026. It has the same finding that Mr. Sells is still not competent to stand trial, but that outpatient commitment is what he meets the criteria for, and that he would require further treatment for competency restoration. Is there any other evidence with regard to competency? Mr. Rojas?
No, Your Honor.
Mr. Coleman?
No, Judge.
So obviously, you both know, we all know that we do not have an outpatient competency restoration program here in Jefferson County. And so I will have no choice but to order further inpatient treatment at the appropriate facility. Hold on just a second. And so I am going to find at this time that Mr. Sells is still not competent to stand trial. that he is mentally ill and that because of that, it is severe and persistent, and that if not treated, he would experience deterioration and the inability to function independently, and that treatment would be necessary. I'm going to order treatment at this point in an inpatient facility for a period of not to exceed 1 year under the civil commitment, and that we will await a report at that time. If something occurs before then where competency is restored, then they will let us know immediately.
Judge, I would like to say, I'm sorry to interrupt the court, but given the nature of these charges, the next time we are in court, if we are in a similar situation, the state will reconsider a way forward
Okay.
in these cases.
Okay, perfect. I know there's some civil, locally, civil commitment that can be taken care of, but let's see if we can get maybe competency restoration between now and the next court date. If not, then we'll go forward that time. So you're going to go back to a hospital, follow all of their rules, okay, so that you can get better, take your medicine, and then we'll see if we can get your case taken care of.
I went to the health center and I went to all the competency.
Right.
With the mental competency with false.
Right. I think the doctors still think they think you need a little more treatment so that you understand all of your legal proceedings. Okay. All right. You can go back with the bailiff. Mr. Rojas will visit with you. Thank you. Smith, I don't think there's any expectation of restoration. I think there's more of an issue of. So anyway, take a look at it.
Yes, Judge. I think there's another way we can go
Okay,
with this.
I agree.
Next time.
Johnny Segeda or Segeda?
I think it's a good one.
Johnny,